Now that we understand the concept of tribe, right? Let's go back. Let's go to clan now. Let's go back. All right. Scottish Highland, common interest. There was something in particular I wanted to point out. Okay. Now now I was talking about the clans, right? So we go to a group of people with a strong common interest. All right? A group of people with a strong common interest. Okay? A brotherhood, the in crowd, right? Clique, circle, a set, group, fraternity, society, community, crowd, band, ring, crew, faction, gang, bunch, sodality, confraternity. All right? Never heard of confraternity before. Heard of a fraternity this year. A confraternity is a brotherhood, especially with a charitable or religious purpose. A brotherhood, right? Especially with a charitable or religious purpose. All right? So that's a new one to know about. Fraternity is a group of people sharing a common profession or interest, right? A common profession, like the profession of police, stuff like that. See what I'm saying? Set, circle, group, profession, right? North American and male students, society and university or college, right? So we already know that. So let's go back again. Okay. You already know the circle is set, in crowd, fraternity. Let's get to something pretty good. We go back to the ones with common interests. All right, society. What's a society? A society is the aggregates of people, right? A group of people living together in a more or less ordered community, right? So either it's more order or less order, but it's still a community. And it's only simply meaning an aggregate of people. So when we say American society, we're talking about the people. So you can create your own society legally. You understand? It's the community, the public, the people, right? Civilization, humankind, mankind, humanity. When it says we, the people, right? And it's understood that we were included in those people. So it's letting you know we are partakers of another society. We are descendants of another society. It's what we claim it because we aren't the ones that literally, you know what I'm saying, started this branch of society, or we didn't start this aspect of it. You understand? Like we from the original branch, right? Which the branch that we're under now descended from, so to speak. And we are part of that descension. You see what I'm saying? We're the derivative of that. All right? Unless you understand the real truth and you go back to the origin, the superior aspect, the ascending aspect, the ascended aspect, so to speak. All right? Without to sound too confusing, right? Okay, well, let's just stick with what we're talking about. All right, define society, right? The aggregate of people living together in a more or less ordered community. The community of people living in a particular country or region and having shared customs, laws, and organizations. Okay? So what society are we a part of, right? And whatever society you're a part of dictates what you're bound to. Okay? A specified section of a community, the aggregate of people who are fashionable, wealthy, and influential, regarded as forming a distinct group in a community. Okay? An aggregate of people who are fashionable, wealthy, the one percenters, and influential, the celebrities and all that. And they what? Are regarded as forming a distinct group in a community. All right? Remember they were saying you could have different tribes or whatever, or different nations within a nation, so to speak. This is kind of what it's saying. All right? You see what they said? It's called high society, polite society, the aristocracy, the gentry. You see, they don't want you to know what gentry means. See, that's why you can't click on that one. The nobility, right? The upper classes, the elite, the privileged classes, the country set, the smart set, the fashionable, the A-list, you see, the wealthy, the beautiful people, the cremette, de la creme, the creme de la creme, the boo Monday, the hot Dundee, the upper crust, the top drawer, the jet set, knobs, tops, swells. All right. So now we'll go back a little bit so we can understand what we're talking about again, right? They say the aggregate of people who are fashionable, wealthy, and influential, regarded as forming a distinct group in the community. And we're talking about society, okay? A society. And they said what we typically think of a society to be, you understand? So a society is a plant or animal community, okay? So the plants and animals have a society. Never considered that like that. Okay, so now it says an organization or club formed for a particular purpose or activity. All right, let's create our own society, people. Association, club, group, band, circle, fellowship, body. Okay, guild, college, lodge. All right, lodge, order, fraternity, brotherhood, sisterhood, sorority, league, federation, union, alliance, affiliation, institution, cathedral, or sodality, right? And understand that all polices are not a part of the union, all right? Some of them are. And as you can see, it's their own society that they created. It's their own brotherhood, you know? It's their own fraternity, right? Just like the lodge, the Mason Lodge, they be like, why they keeping secrets and stuff like that? Because it's their own society. If you want to know what's going on, you have to become a part of their society, you see? And so when you join a college, you're a part of that society. You got sororities and all that. It's under the same order, right? So these are all the different orders, you see? So the ones that can follow, everybody can follow, I know that. All right, so now it says the situation of being in the company of other people, okay? It says the situation of being, right? Just being at a party or something like that, you're amongst a society of people. A friendship, comradeship, you know, companionship, company, right? You have a company, you have a society. So you develop yourself a company, boom, you got a society. Even though we know we're talking about a company of people, right? A company of people is a company of organization, all right? The people makes the organization will make the people, all right? So boom, companionship, friendly, association with others. All right, 16th century, so it's like 1500s. All right, in the sense of companionship, friendly, association with others. That's all it was in the sense of. Okay, meaning a companion. All right, let's go back. So now that we pretty much get the gist of that, you go check out other synonyms, right, y'all? You understand what's actually going on. So that was clan. Race. We talking about is racism and stuff. Race this, race that, this and that, right? So a race is a competition between runners, horses, vehicles, boats, etc. to see which is the fastest in covering a set course. Okay? Who's the fastest at covering the course? Time trial, right? A series of races for horses or dogs held at a fixed time on a set course. A situation in which individuals or groups compete to be first to achieve a particular objective, okay? A rivalry, contest, or arcade. The course of the sun or moon through the heavens. All right? This is like the oldest understanding of what race means. Race initially meant the course of the sun or moon through the heavens. All right? The race of time. All right? Just so we don't get it twisted. So that sounds like a date, right? The course was a course. I mean, the travel of it, of the sun and moon, right, through the heavens, and it keeps going. It's a race over and over. So when we speak of racist, okay, we're speaking of the days. All right. So now, a strong or rapid current flowing through, or a narrow channel in the sea or a river, a race, like waterway, stuff like that. So the racist, the waterways, and all that. All right. A water choke, okay, a smooth ring-shaped groove or guide in which a ball bearing or roller bearing runs, complete with another or other to see who is fastest, will compete, at covering a set course or achieving an objective. All right, so everybody's in a race against us, so to speak. Compete regularly in races as a sport or leisure activity. Prepare and enter an animal or vehicle in races as sport or leisure activity. Move or progress swiftly or at full speed. Operator cause to operate at an excessive speed of a person's heart or pulse. Be faster than usual because of fear or excitement. All right, but now, okay, now so now the origin is basically a channel, a path. All right, a race. So now when we get to the race that most people speak of, right? We're talking about each of the major divisions of humankind having distinct physical characteristics, right? An ethnic group. You understand? That's where we're going with this. Right? And it says each of the major divisions of humankind having distinct physical characteristics. All right? Like hair, skin, stuff like that. All right. And it's the only synonym it has, ethnic group. The fact or condition of belonging to a racial division or group. The qualities or characteristics associated with this. Okay? Everybody has different qualities and characteristics. So one ethnic group can't rule over another ethnic group, because we're strikingly different. All right? It says a group of people sharing the same culture, history, language, etc. Right? An ethnic group. People, a nation, right? Ethnic group. A group or set of people or things with a common feature or features, all right? With a common feature or features, like skin, hair, stuff like that, like I was saying. Okay, you have group, type, sort, class, kind. Everybody, mankind, right? What kind of man are you? What type? What species? What breed? What order? What caste? What style, right? Biology, race. A population within a species that is distinct in some way, especially in subspecies. Okay? In non-technical use, each of the major divisions of living creatures. Now, it's you know too, right? In race, right? It's a population with a species that is distinct in some way, especially in subspecies. That means in science, we're actually different races are. All right, literary. It's like things that's written down. A group of people descended from a common ancestor. A group of people descended from a common ancestor. All right, race, family line, blood, folk, stock, dynasty, house. Right. So like the house of Jacob, the house of this, a tribe. Okay, a tribe. Let's say a clan in this mix. Sure it is. Clan, tribe, ancestry, bloodline, progeny, right? Offspring issue. I would understand it can be political or whatever, you know what I'm saying? Your race, you understand? All right, race number 3 is a ginger root, okay? A ginger root is a race. I guarantee you, there's something symbolic about a ginger root. Let's check it out right quick. Y'all know on those. Ginger root. Symbolic. Symbolic meaning. Uh, 10 ways to use ginger in witchcraft. Ginger root is used to bring good luck. Ginger root essentials. Ginger root oil profile, right? Herb magic. So it's dealing with witch stuff, like, okay, spells, good or bad, right? Magical property. All right, now let's read this part. It says the magical powers of ginger root. Ginger is associated with the force of fire and the sun. Okay? With the force of fire and the sun. Ginger can represent limitless prosperity and diversity in the personality. Right? Ginger root is beige in color with a knotted, rough appearance. All right? So a spirit food. You hear your grandma talking about that ginger all the time? Ginger. Biblical meaning of ginger. Let's see what it means. Check it. Sorry, we couldn't find that. Alright, so yeah, we get it. So it's dealing with race though. Root. Okay. Unknown origin for this aspect of race, right? Now we know the first one. It says Old English, or Old Norse, Rod meaning current, right? Race meaning current. It was originally, meaning energy. It was originally a Northern English word with the sense rapid. Okay, rapid forward movement, right? Rapid forward movement is a race, which gave rise to the senses context of speed, okay, and channel path, right? The space traversed, movement basically. All right, so let's get back. Trying to go too deep. So let's go into nation right quick. Well, status. All right. So it said the status of belonging to a particular nation. All right. Status is what? The relative, social, national. This is the relative, social, professional, or other standing of someone or something. The relative, social, professional, or other standing of someone or something. All right? So your rank, your ranking, your position, your station, level, footing, right? So we form our own nation and stuff. Like, what status are you in? So high rank, social standing, okay? What's the social standing? Status, right? The official classification given to a person, country, or organization, determining their rights or responsibilities. You understand? The official classification given to a person, country, or organization, right? And what determines their rights or responsibilities. So you form your own nation and have your own officers and all that. Say this is your right and your responsibility according to what you stand for. It don't matter what nobody else talking about what you stand for. You see what I'm saying? What's your status? What's your legal standing? All right, so say the position of affairs at a particular time, especially in political or commercial contexts. Okay? A posting on a social media or your status, like social media status. So it means standing. Status means standing, okay? Like, what's your standing? What's your status? It means to stand, okay? Legal standing, right? Late 18th century as a legal term, meaning legal standing. Status means your legal standing. So us as black people, so to speak, not to down us or nothing like that, if we claim to be a part of America and all that, our legal standing is American. But do we actually have a legal standing? Do we actually have a status within this nation? You see what I'm saying? And then if we do, what status is that? What standing is that? Is that the standing of a slave? You see? You have to be careful about these things. Like, what's your legal standing? ADOS? Are you coming from the legal standpoint as being a slave? Huh? You coming from the standpoint of being inferior or superior? But I ain't knocking nobody now. I'm just saying we got to really look at what's going on. What's your legal standing? And then according to who, right? So you got to position yourself to have your own legal standing. So you can state what your legal standing is. You understand? Okay. So now, we dealt with legal standing. So now we're in nation. But we're going to get more into legal standing too, just so y'all know, all right? So now, nation is a large body of people united by common descent, history, culture, or language, inhabiting a particular country or territory. You understand? It's a large body of people united by common descent. Okay, like all those commonly are black people, so to speak, right? People of color. History. Basically we know that we all been living here for a long time. It's our history. Our culture. What we into, the things that we believe in, and all that. Our language, the way we speak. We can understand each other, inhabiting a particular country or territory. So we live here. We are inhabitants of this country or territory. All right? Even though it's not ours, so to speak. So, but we can have our own. If we create our own nation, we can have a nation, within a country or a territory. All right? The same way the United States is. All right. So now, when we talk about nation, we're talking about a country, a state, land, nation state, kingdom, empire, republic, confederation, right? Confederates of America, right? Federation, Commonwealth, the British Commonwealth, and all that. Power, superpower, polity, domain, domain name, business domain, all that type of stuff. Fatherland, motherland, people, race, civilization, tribe, society, community, right? Population, body politic, populace, public realm, res publica, okay? So a North American Indian people of Confederation of Peoples, you see? A North American Indian people or Confederation of Peoples, right? So you got the Confederate flag, that's what we're talking about. This, you got to get your legal standing together. So it says Middle English via Old French from Latin natio, from nat, born, from the verb nasi. Oh man, look at that. Nasi, from the verb nasi, nation, nasi. Okay, the Nazis, the nation, you see? All right, anyway, let me go to concept. Let's click out of this, deal with nation. I don't see how I'm not. Okay, let's deal with descend since this is what I'm on. Right? Descend mean to move or fall downward, right? Or stairs, a road path, peaceful land, be on the slope. Okay? Move down, slope, you know what descend mean. Go down and all that. I'm trying to get back to nationality. Alright. Nationality is the status of belonging to a particular nation. Right? We just ran through what nation is and all that. So you could be your own nation, you could be your own country. Alright, the second definition. Well, let's go ahead and go into citizenship right quick, since we know we're a citizen of the United States of America. So you can understand clearly what that means. So it's the position or status of being a citizen of a particular country, right? So like I was saying, what's our position? What's our status in being a citizen of the United States of America? And do you agree to that? Agree to that status or position? Or are you aware that what's your position or status, so to speak? Because it seems like we are in a low position, and that we have a low status in this particular country, right? Not meaning the land, meaning the system of it. See, the system is the country, right? All right. So let's see. So the second definition is an ethnic group. We already went through ethnic group, forming a part of one or more political nations. Okay. So let's deal with political nations. Let's deal with a political nation. What's a political nation? Not giving it to me where I want it. Trying to see if I got something else up about political nation. It doesn't appear. So, all right, but anyway, we already read nation though, but let's read it again. It's Wikipedia right here though. It says, a nation is a stable community of humans formed on the basis of a common language. Common language, territory, history, ethnicity, or psychological makeup manifested in a common culture. A nation is more overtly political than an ethnic group. It has been described as a fully mobilized or institutionalized ethnic group. Okay? So it's more overtly political than ethnic. Okay, let's check out political. What's political? Okay, political is related to the government or the public affairs of a country. So understanding, you can be your own political nation, right? And political nation, being political is dealing with government, local government, ministerial, okay? Parliamentary, diplomatic, legislative, policy making, constitutional, public, civic, state, administrative, bureaucratic. You understand? So we are a part of a political nation as well. You understand? When you're part of a nation, You're part of everything that comes with it and the position that they place you in it. You see? So now, understanding this, that we're dealing with a political nation because we have all these things, okay? So, and we know we have politics, right? So now, relating to ideals or strategies of a particular party or group in politics. You see? Relating to ideals or strategies of a particular party or group in politics. Okay? What is it? An activist, active, militant, factional, okay? Partisan, party. So now, we got to deal with what politics is first, in a minute. So we know what political means, what is politics, right? But interested, or you say interested in or active in politics, motivated or caused by a person's beliefs or actions concerning politics. So it's nothing concrete, right? Derogatory. You have your own politics, right? I don't do to pull out derogatory stuff. So let's go into politics real quick. What is politics? Politic is of an action seeming sensible and judicious under the circumstances. Of an action, right? Right? Seeming sensible, seeming, and judicious under the circumstances. I mean, ain't no certain, you know what I'm saying, thing. This is whatever a person think. Right? Wise, prudent, sensible, judicious, canny, sagacious, expedient, shrewd, astute, discreet, tactful, diplomatic, recommended, adventurous, beneficial, profitable, gainful, desirable, advisable, right? You get it. The definition of the origin is what? The origin of politics is what? Late Middle English, from Old French, politique, meaning political, via Latin, from Greek, politikos, from politis, meaning what? Citizen. From polis, meaning city. So politic means city. And it means citizen. So the politics mean a citizen, right? We are citizens, that means we are cities. You understand? We are cities that make up a city, right? So, I'm from Pensacola. So I am a city called Pensacola, which makes me a Pensacolian, right? Because I'm a part of the city of Pensacola, which are the people of Pensacola. Well, from, you know what I'm saying? From the culture, from the origin, from, you know, things like that, right? Like where you birthed at, where you first, you know, boom. Y'all get what I'm saying. Y'all see how sick and how intricate it is, though, right? Politics means citizen. So they politicking for citizenship. Where you gonna be a citizen of the Democratic Party, or you gonna be a citizen of the Republican Party, even though they both are a part of the country, United States, but it's different facets within it. You see? See what's going on here? So one wants to lead the country one way, right? Depending on all the citizens that participate in this country, right? Determines which way direction the whole country goes by majority rules, so to speak. Whether you want to go to the left or to the right. But left or right not meaning a certain direction, it just means just this side or that side. Because the left can also be the right and the right can be the left, but it just, hey, but y'all get what I'm saying. I hope y'all get what I'm saying. All right, so let's come out of politics. So since we understand it being a city, right? Interested in or active in, right? Politics in the cities. Motivated or caused by a person's belief or action concerning politics, okay? Regarding citizenship, basically what they're saying. Okay, we've already been through this. Get back to nationality. So, we understand political nations. Nationality don't have an origin. Let's deal with this. You know what? On the next video, y'all, I'm gonna deal with what legal standing actually is. It's very, 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 very deep. But let's go into standing though, right quick. It's very deep. Let's see how long this is. I ain't trying to go too deep. We give y'all the basis of what standing actually is. Then we'll go into an article that's actually really, really, really giving it to you. But it's kind of like a real sidebar, to be honest. Okay, but let's deal with standing in the law, you see. Standing. We say in law, standing or locus standi is the term for the ability of a party to demonstrate to the court sufficient connection to and harm from the law or action challenged to support that party's participation in the case. Standing exists from one of three causes, right? So when you go into court, it's letting you know you're trying to show the standing, right? You're trying to demonstrate to the court. Okay, it's an in law, right? Standing or locus standi is a term for the ability of a party, okay, to demonstrate to the court sufficient connection to and harm from, okay, the law or action challenged to support that party's participation in the case. Okay, and it says standing exists for one of three causes. Okay, the party is directly subject to an adverse effect by the statute or action in question, and the harm suffered will continue unless the court grants relief in the form of damages or a finding that the law either does not apply to the party or that the law is void and can be nullified. Okay? This is called this is called the something to lose doctrine. So now, when you hear Donald Trump say, you guys don't have anything to lose, what is he saying? He's saying we don't have any standing. We have to gain something to lose. All right? It's a something to lose doctrine in which the party has standing because they will be directly harmed by the conditions for which they are asking the court for relief. So now, if you're about to get locked up or something like that, the idea is to prove standing that, hey, you can't be convicted or anything like that because it's going to hurt your person. It's going to hurt you as a person. You see what I'm saying? Because they can't legally do anything to you because it's not really real. It's all fictitious court. You feel what I'm saying? So they can't do nothing. Technically, they're not supposed to be able to lock you up unless you give consent. But if you don't have a standing, if you don't know how to stand in front of your opposition, then you'll be swept under the seas, basically. All right, but you got to peep the language in what they're talking about. Okay? So now, It says the party is not directly harmed. That's the first way to show your standing, right? The second way to show standing is if the party is not directly harmed by conditions by which they are petitioning the court for relief, but ask for it because the harm involved has some reasonable relation to their situation, and the continued existence of the harm may affect others who might not be able to ask a court for relief. You see? In the United States, this is the grounds for asking for a law to be struck down as violating the First Amendment to the Constitution of the United States. Come on, y'all. Come on. Y'all hear what this just said? It don't even have to harm you. It could be affecting somebody else. And since you are in the court to show, you are in the court to present. You're not in the court to be convicted, right? You're in the court to let them know that you are here to state your standings, that you can't answer to these charges because of the fact that it's going to negatively affect you or the people you're connected to. You see what I'm saying? Right? And they say it's direct violation of your First Amendment, U.S. Constitution. Okay? And it says because while the plaintiff might not be directly affected, the law might so adversely affect others that one might never know what was not done. They say one might never know what was not done or created by those who fear they would become subject to the law. The so-called chilling effects doctrine. You see, they got doctrines with this stuff, legal stuff, y'all. This ain't no cap. This ain't no conspiracy or none of that there. Listen, now the third way to show your standings is if, right, it say the party is granted automatic standing by act of law. Okay, say the party is granted automatic standing by act of law. Okay, they say under some environmental laws in the United States, a party may sue someone causing pollution to certain waterways without a federal permit, even if the party suing is not harmed by the pollution being generated. The law allows them to receive attorney fees if they substantially prevail in the action. In some U.S. states, a person who believes a book, film, or other work of art is obscene may sue in their own name to have the work banned directly without having to ask a district attorney to do so. So now, books, right? Films and other works, like teaching families and stuff, teaching kids that it's okay to be homosexual or whatever the case is. You know what I mean? Not necessarily, talking down about it, but I'm just saying, like things that we deem to be obscene. To me, that's obscenity. So, therefore, it's saying we have the right to sue to have that taken down without a district attorney. Okay? They say in the United States, the current doctrine is that a person cannot bring a suit challenging the constitutionality of a law unless the plaintiff can demonstrate that he, it, is, or will imminently be harmed by the law. Otherwise, the court will rule that the plaintiff lacks standing, you see, to bring the suit, and will dismiss the case without considering the merits of the claim of unconstitutionality. To have a court declare a law unconstitutional, there must be a valid reason for the lawsuit. The party suing must have something to lose in order to sue, unless it has automatic standing by action of law. Okay? So the last part again, it says, in the United States, the current doctrine is that a person cannot bring a suit challenging the constitutionality of a law unless the plaintiff can demonstrate that he, it, is, would imminently be harmed by the law. So you can bring a suit if you can show you will be harmed by the law. It say otherwise, the court would rule that the plaintiff lacks standing to bring the suit and would dismiss the case without considering the merits of the claim of unconstitutionality, right? So if someone's violating your constitutional rights, that's called unconstitutionality, okay? And it says to have a court declare a law unconstitutional, there must be a valid reason for the lawsuit. Okay, so first you gotta have probable cause to say that a law is unconstitutional, right? Laws is not the Constitution, okay, people? Now, we have to show that laws are unconstitutional, showing that it's violating our constitutional rights to where it causes imminent harm. You see, like us getting killed with the policies and procedures that's going on is showing imminent harm. So the laws that they say that we must obey can be deemed, we can bring a lawsuit against that, you know what I mean, and deem it to be unconstitutional, you see? Right, it say the party suing must have something to lose in order to sue, though, unless it has automatic standing by action of law, okay? So we got to get a standing as well, and then it says unless it has automatic, you know what I'm saying, a standing, right? And it says the party is granted automatic standing by act of law, right? Under some environmental laws, and with let's see what that means. Environmental law is a collective term encompassing aspects of the law that provide protection to the environment. A related but distinct set of regulatory regimes, now strongly influenced by environmental legal principles, focus on the management of principal natural resources such as forests, minerals, okay, stuff like that. All right, but they talk about land for that on that part. All right, so it say United States, a party must sue someone, okay, may sue someone. Okay, we already went through that. All right, boom. But y'all get what I'm saying about this constitutional shit, about the standing. All right, so that's just a little light something. But on the next video, I'm gonna give y'all this real deal about the standing. You know what I mean? With the shit. There's a lot of shit in here about this. About the real standing. You see public interest litigation and local standout. All right, and it really lets you know public interest litigation, the background. You see what I'm saying? From coaching university law review. Let me see real quick. We say USA. Let me just read the first part of it. Y'all can't see it that good, I don't think, but let me just read it for you. It say, in the past, the paradise of justice was the monopoly of the affluent, who alone possessed its golden key. This class-oriented common law system of dispensation of justice is now giving way to a new mass-oriented jurisprudence, right? And it's a wave of public interest litigation, which brings the goddess of justice to the illiterate and exploited has set in. Wow. It say this new trend derives away the past evils of legal technicality and procedural rigidity. Or rigid, I don't know how to say that, y'all, sorry. It's like rigidity. Rigidity. Yeah, that's how you say it. Rigidity, okay? It's a liberalization. Let me make this shit a little bit bigger so y'all can see. So I don't be confusing y'all so y'all can read on your own for the ones that can automatically understand what it's saying. All right. So now it's a wave of public interest litigation, which brings the goddess of justice to the illiterate and exploited, and exploited has set in. This new trend drives away past evils, right? Y'all see what I'm at, right? Past evils of legal technicality and procedural rigidity. Liberalization of the need to prove locus standi for invoking the jurisdiction of the court is the most notable phenomenon of this change, right? It say, listen, it say in order to invoke the jurisdiction of a court, right? You got to prove. You say, okay. It say liberalization, right, of the need to prove locus standi for invoking the jurisdiction of the court. It's the most common notable phenomenon of change, okay? So let's keep going so y'all can understand what I'm saying. It said the rudiments of public interest litigation can be traced to Roman law, under which it was open to any person to bring what was called an actio popularis in respect of public delict, or to sue for a prohibitory or restitutory interdict for the protection of res sacra and res publica. The actio popularis may be the ancestor of our public interest litigation. Okay, so then you notice the origin of it. They say in England, there was, from the very early days, the device of relative action. The foundation of this principle is the interest of the crown as parents, right? Patriarch. That's where you get the patriarch from. And the crown was as parents, upholding the law for the benefit of the general public. The crown is interested in seeing that public bodies discharge their functions properly and that they do not abuse or misuse their powers. This device imposes a measure of control over situations where otherwise members of the public might bring uncoordinated actions, resulting in confusion, right? That's the whole point of putting up the court, is what they're trying to say. Basically, this is a regulated form of actio popularis. In the USA, in USA, the administrative agencies were considered to represent the public interest, okay? The agency proceedings were to be the forums for vindicating public interest. Litigation in public interest began acquiring popularity in the US in the early 60s. Okay, what did? Litigation in public interest. They say the reason was the failure of the administrative agencies, referred to as the fourth headless branch of the state, after the executive, legislature, and judiciary were conceived as instruments to regulate the powerfully organized private sector. They were intended to streamline the administration in such a way as to better serve the interests of the public. The agencies had to discharge a variety of functions ranging from dispensation of social benefits to control of multinationals, protection of environment, and the consumer public. Okay? They say in these matters, they were vested with powers to take important decisions and to implement them. But by the 60s, it became clear that these agencies had failed in protecting the public interest due to their purposive inaction where action was called for. Okay? So they didn't take action where action is called for, and they failed to abide by protecting public interest, to abide under the agreement of protecting the public interest, right? To serve and protect, okay? It's two factors that led to the failure of the agencies, police agencies, help the development of public interest litigation. They say the first was what the Americans call agency capture. Powerfully organized private sector, which was to be regulated by the agencies, captured the agencies themselves, and they began to play to the tune of those against whom they were expected to act. The second factor was the failure of the agencies to recognize the existence of large and diffuse interests in society, which were badly disarrayed and unorganized. Thus, the administrative agencies became what are called the low visibility areas of decision making. The diffuse interests could not get redress for their grievances. Cannot get redress for their grievances, either in the legislatures or administrative forms, because both these forms were controlled by powerfully organized and vested interests. So these interests had only the judicial form to turn to. The public interest law emerged as a means to vindicate the rights of minorities and weaker sections in society like women, children, the physically and or mentally handicapped, the poor, the consumer public, environmentalists, etc. Okay, let's go back. It says, so these interests had only the judicial form to turn to. The public interest, right? The public interest law emerged as a means to vindicate the rights, to bring out the rights, to give us the rights, right, of minorities and weaker sections in society, right? Like women, children, the physically and mentally handicapped, the poor, and the consumer public, environmentalists, because of the problem of access to court, lack of standing to litigate, or economic disabilities, right? So it say the existing legal system failed to protect these interests, right? Why did they fail to protect these interests? Because of the problem of access to court. Why couldn't they access to court? Because they lack standing, right? Lack of standing to litigate. You don't have a foot to stand on. You know how to say you don't have a foot to stand on? This is what they're talking about. You don't have a window to piss in, and you know what I'm saying? Oh shit, y'all don't have, you know what I'm talking about. You don't have a window to piss in, a pot to piss in, or a window to throw it out, right? You don't have a pot to piss in or a window to throw it out. You don't have a leg to stand on. You don't have legal standing, is what they're saying, okay? You don't have a nation, all right? A tribe, anything like that. They said, or economic disabilities, okay? You don't have the money to put up to get the lawyer to stand for you because you don't have legal standing, okay? And even if you did, you don't have a group around you that's making things move. But anyway, they say the public interest lawyers were instrumental in finding their way out of this impasse. So the lawyers, the public interest lawyers, so there's lawyers called public interest lawyers. So I guess with the people that stand up or whatever, that come out when people get born or whatever, I forgot that black guy name, I guess he's a public interest lawyer, okay? They said with financial support from the Office of Economic Opportunity, AEO, of the federal government of the United States, these lawyers mobilized law students, right? These lawyers mobilized law students and social action groups, okay, to articulate within the legal framework. They say with financial support from the Office of Economic Opportunity of the federal government of the United States, these lawyers mobilized law students and social action groups to articulate within the legal framework to diffuse interests of 7 million unrecognized people in the lower socioeconomic strata, and to force the system to change its priorities, right? Procedures and politics for the benefit of those who were till then kept outside it. Of those who were till. Oh, okay. For those who were till then kept outside of it. Right? So let's go back to the last sentence. Let's make sure I flow it out right. It was the long run on sentence. Anyway, the last comment or something like that, right? It say, yeah, let's go back to that part. It say groups to articulate, which I want to start from. To articulate within the framework, right? Within the legal framework, the diffuse interests of several million unrecognized people, right? They only recognize us, right? What people they don't recognize? People in the lower social, right? Social economic strata. And to force the system, right? We're not a part of their social economics. Their group, the way they're making their money, that's social economics. Like, I do business with you, you do business with me, we do business with each other. You know what I'm saying? Right? And they say to force the system to change its priorities, procedures, and politics for the benefit of those who were till then kept outside it. Objectives. The objectives of this device, therefore, are principally four. And the device they're talking about is the law. What is it called again? Talking about, where is that? So we can stay on point, y'all. The public interest law. We're talking about the public interest law. That's what we're still talking about here. So it says objectives of of this law. It said the objectives of this device, which they call in the law, therefore, are principally four. Representing the diffuse interest in society. Let's go ahead and look at that word so we know what the hell that means. Keep on using it. It's a spread or cause to spread over a wide area or among a large number of people. Spread out over a large area, not concentrated. Okay? So that's what it means. So diffuse interest in society, right? Representing the diffuse interest in society, the spread interest in society, the overall interest of everybody, right? Spread something over something, right? So they're representing the overall interest in society. Okay? Securing justice, political as well as social, to the extent possible. To the extent possible. That's the clause that we messed up at. To the extent possible. What you mean? All the way. You know, to the extent possible, right? To the economically and socially handicapped. To the economically and socially handicapped, not the black people. So they got this clause, right? And the objective of this clause is to represent and diffuse interest in society, right? Spread the interest of everybody in society, right? They represent. And it says to secure justice, right? Political as well as social. To who? To the extent possible, right? What? To who? To the economically and socially handicapped, meaning the people that can't. See? Are you an able, capable human being? Where does this law end for you? So they can still do whatever they want. Okay, now listen. Now, the third part is ensuring that the administrative and other political machinery work in a way subservient to the interests of the general public, right? Operate in a way that's subservient. Operate in a way that is prepared to obey others unquestionably in a submissive way. Differential way, a compliant way, right? Subsidiary way, less important, subordinate way. Come on, man. Serving as a means to an end way. Stop it. Right? In a way subservient to the interests of the general public, but not for the general public interest, what they're saying. What the hell, who wrote this? And they say brittling the law enforcement machinery itself to move towards social justice. It's a bridling the law enforcement machinery. So they call it law enforcement a machine. What? Right? Itself to move towards what? Social justice. Okay? Meaning being just in the social framework that we have, that we have a pledge to be a part of, right? So it's a bridling the law enforcement. What the hell does this mean? Brittle. Put a brittle on a horse. Show one's resentment or anger, especially by throwing up the head, drawing in the chin. Okay? Right. Sound like some woman stuff. Use the form of action of a horse when reined. Okay? Bridle. Look at a horse when it's being bridled. Holding the police back is what they're trying to say. Bridle, the headgear used to control a horse, consisting of buckled straps to which a bit and reins are attached. Okay? So now, look at a couple of pictures right there. Putting the head down, like being like man type shit. Then they look like angry. All right, so it's a bridling the law enforcement machinery itself to move toward social justice. So we looking at it with our head down, like move towards social justice, right? This ain't making nobody do nothing. This ain't no law. You know what I'm saying? All right, the coaching university law review, right? They say the courts try to further these objectives by increasingly allowing resort to public interest litigation, but our current procedural norms place innumerable hurdles in the way of a prospective litigant, okay? Those seeking justice will have to overpower these hurdles. Overcome these hurdles, which overpower, yes. You hear what they're saying though? They got a law set, but they're making it hard to apply. And the reason why is because it is not wrote right anyway. Now the problem is this. Say the problem. We have the adversary system, right, of court procedure as opposed to inquisitorial. Adversary system requires parties opposed to each other to place evidence before the court to prove each other's case. Okay? They put opposing parties in there. That's what they're trying to say, right? And they say the court decides the case on the basis of who has given the best evidence and does not inquire further. So also, the court will adjudicate only if a matter is brought before it by somebody. Therefore, as far as public interest litigation is concerned, all members of society must be encouraged to bring before the court situations that warrant courts' intervention. Such a course will help bringing before court vital issues. Such a course will help bringing before court vital issues of public interest, which require urgent solutions, converting the judiciary into a machinery sensitive to the injustice suffered by people, and thus securing the ends of distributive justice and participative democracy. But the biggest roadblock obstructing the judiciary against adopting a social justice oriented and liberal attitude is the traditional concept of locus standi, or standing, which the courts are reluctant to discard even today. Right? It say, but the biggest roadblock obstructing the judiciary against adopting a social justice oriented and liberal attitude is the traditional concept of locus standi. Okay? So now, and it says the courts are reluctant to disregard, like write it off even today, right? So now, what is locus standi according to this? It's a locus standi. This concept prescribes that unless a person has suffered a direct injury or is aggrieved by the act he proposes to challenge, his action is not maintainable in court of law. Thus, when an environmentalist approaches a court with an environmental problem, instead of considering the larger public interest, the objects of environmental law, the need for distributive justice and participative democracy, the court focuses its attention on the identity of the person who brings the action. The questions asked are, who is he? Is he personally affected? Has he sufficient personal interest in the matter, in the issue? Okay? So it says if you don't have correct standing, they're going to automatically size you up as the person. So it says if you don't come to them with the need of distributive justice, right? Distributive meaning spread out among everybody. And participative democracy, meaning the help for the courts to participate. That means we're not going to be able to get this distributive justice unless the court show relief, right? So if you don't show that, then they're going to attack you to see how it's personally affecting you and what you deem to gain out of the situation. All right, so evolution of the concept. Locus standi is a vintage doctrine, okay? Its genesis is in the common law of the laicist fatheric dominated England, right? Like what Wikipedia was kind of saying. They say the king ruled the country, collected taxes, waged wars, and maintained a general order in society, okay? It says the subjects were left free in all their activities, provided they obeyed the laws. In individual disputes alone, conflicting parties sought justice. The nature of litigation in courts in the early days was essentially contractual. The rule of privity of contract is what it was called, right? Governed the field. The laicist fatheric philosophy, right? This is a philosophy, left the individual absolutely free, and freedom of contract was regarded as inviolable and sacrosanct. The sovereign did not interfere with that freedom except in very few cases, opposed to public policy. With the advent of democracy, right, with the adventure or the invention of democracy, the century of power shifted from the king to the representatives of the people elected and assembled in parliament, right? They had to face elections periodically To ensure their re-election, it was imperative for them to serve public interest in their endeavor to promote a welfare state. Okay? The representative institutions assumed more and more powers, and welfare litigation proliferated. This involved more and more regulation of the citizens' freedom and conduct. Thus, the man in the street began to come into constant contact with the state in his everyday life. Right? The state, meaning the democratic state. They say with its spawning laws and increased powers, the state frequently infringed the rights of the individuals. Whose right being infringed? Ours, the black people, right? The colored people. This threw up a new type of litigation with the citizen pitted against the state. Or pitted, my bad, against the state. So to let you know how it became opposing deals instead of everybody being on the same team, just right is right and wrong is wrong aspect. Okay, say rule of law required that every executive action should be supported by law. Okay? Therefore, unlawful acts of the state were questioned in courts. The question then arose as to who could question such illegal state acts. The courts answered that the legality could be challenged only by a person adversely affected. Okay? So somebody that's affected is the only one that can challenge the state. They say under the circumstances, this was the only way in which the executive powers could be accommodated. It was thus that the concept of local standard was evolved, right? So that's where this have your own standing comes in at. This is the only way you can stand up to the system. Okay? They say standing or local standard is the right of a person to sue or to seek relief in a court of law, as distinguished, right, from a substantive right or interest possessed by him, and which is alleged to be infringed or endangered by a state action. You see, we stand under the grounds of substantive right and interest possessed, right? Because we're saying, hey, you're infringing on my rights and stuff like that. You see what I'm saying? We're not coming from the standing of local standard. Okay, substantive, right? Let's see what that means, substantive. Substantive. Told y'all, man, y'all gonna know all about what's going on now that all these boys, all these people talking this stuff. It's kind of what they're talking about. All right, substantive is having a firm basis in reality, okay? And therefore important, meaningful, or considerable. Having a separate and independent existence. Having an independent existence. Okay? Instead of group existence. Alright, so let me read this again so we can follow what's going on from the top. It says standing or local standard is the right of a person to sue or to seek self-relief in the court of law, as distinguished, different from a substantive right or interest possessed by him and which is alleged to be infringed or endangered by a state action. So they say they can trample on your shit with some kind of law or something. They say it is this factor that gives the litigant the personal qualification to challenge an illegal administrative or legislative act. Two principles have been held to underlie the concept of local standard, okay? I'm going to give us two examples. The first one is the petitioner, litigant himself must have a grievance. He cannot base his claim on the grievance of another person. But this is not necessary in writs of habeas corpus or quo warranto, because personal liberty and usurpation of public office are accepted to be of general public concern. Okay? So it says the way out of this through the habeas corpus and the quo warranto, right? So we gotta look into that kind of stuff. They say no one can bring to court a purely academic dispute. Some legal right or interest of the petitioner must be infringed. Okay? So like the petitioner is like the state prosecutor, stuff like that. You know what I mean? They can't bring you to court unless they have been infringed on. You see what I'm saying? Right? So it say no one can bring to court a purely academic, like just by laws, right? So you violate the law and because of this statute, this, no. They say no one can bring to court a purely academic dispute. Say some legal right or interest of the petitioner must be infringed, threatened, or clouded, so that the controversy which he raised in court should be focused on his individual grievance and interest on which the court can pronounce. You see? The court's got to be able to say, hey, according to this is why we're here, okay? And it got to be something that's personally hurting the state prosecutor and stuff, right? So now, it say this traditional concept of locus standi was strictly enforced and consistently insisted upon by the courts in India, England, and the USA for a long time. Different pronouncements regarding the personality of litigants governed the field then. No concrete criteria could be spelled out from these decisions to determine the locus standi of a litigant beforehand. The courts used to insist interchangeably on requirements like legal right, special interest, sufficient interest. We gotta look these things up, and whether the duty sought to be enforced is owed to him. Okay, in India also. Okay, a lot of that, but y'all get it. That's basically the whole deal. So you have to study these things individually, look up what a legal right is, special interest. So to see if you violate the legal right of the state prosecutor and shit, or whoever bringing charges against you. You see what I'm saying? And so basically the court is suing you. Is basically what it's saying. So when the police officer charge you with a crime, they're basically saying they're suing you. Okay? So you got to have a good standing for yourself. For real, for real. That's what we're talking about. But yeah, man, I hope I didn't bore y'all with all the information I gave y'all today. You know, I definitely thank y'all for paying attention and stuff like that there. And yeah, for the most part, I was giving y'all what the understanding of nationality was and what a nation is, and have you to understand that that's a legal standing. So you can have a legal standing of being a Christian or a this or that or whatever the case, right? But it don't really have a protection under it because it's under the umbrella and fold of a larger organization, you know what I mean? Like Catholics or something like that, or Catholicism or whatever the case, have branches, you know what I mean? Which could be Christianity or this or that. It all descends and branches from something. So you just gotta know what the branch is. And so like I'm saying though, that you can form your own nation, you can form your own club, your own tribe, your own clan, and go from there, even if it's from a family standpoint. Like, hey, this is my clan, this is my tribe, the people that in my immediate family. And then other people in their immediate families form their clans and their tribes, so on and so forth. And then you have a community that's a clan or a tribe. And then these become a collective, you know what I mean, to form a united clan or tribe, you see? So that's how you get a legal standing and legal footing. So that way you can show yourself as being separate and not under the jurisprudence of someone else's nation or a collective body of ideas, which is laws and stuff like that. And you got to fall under their rank or under the status that you're placed in according to them. You see? So that's what's really going on about this nationality thing, But once you understand that you are your own city, you're a citizen, which you are your own state, you just have to stand on that. And you have to know what that is, you understand? So you have to know the grounds and principles that you stand on. So yeah, man, like I said again, I definitely thank y'all for tuning in one more time. And I know for the bright minds out there, it's a lot of things that were said that you'll be able to run off with. And as you can see, we could have went so many other places. But for the sake of time of the video and all that type of stuff, I'm gonna go ahead and end it right here. And like I say, I appreciate y'all once again for tuning in. Peace.